A big win for Fulton County District Attorney Fani Willis in the RICO case in Georgia, and a big loss for Donald Trump. The Superior Court judge presiding over this case, Judge Scott McAfee, just denied Donald Trump's motion to dismiss the indictment on First Amendment grounds. Donald Trump and some of the co-defendants joined together in that motion. Take a look at some of the language used by Judge Scott McAfee here in the Georgia criminal RICO case against Donald Trump. Some pretty tough language right here. For example, it says, after interpreting the indictment's language liberally in favor of the state as required at this pre-trial stage, the court finds that the defendants, referring to Donald Trump and his RICO co-conspirators, that the criminal defendants' expressions and speech are alleged to have been made in furtherance of criminal activity and constitute false statements knowingly and willfully made in matters within a government agency's jurisdiction, which threaten to deceive and harm the government. McAfee's order goes on to say, nor is a false statement knowingly and willfully made in a matter within a government agency's jurisdiction and which threatens to deceive and harm the government free from restrictions at all. Then it goes on to cite certain cases that talks about there's an importance to protect the government's integrity here. And so what Judge McAfee is saying is, look, here's an understanding of what the First Amendment is all about. The First Amendment means that the government has no power to restrict expression because of its message, its ideas, its subject matter, or its content, and that the laws regarding speech outside categorically excluded forms of expression are subject to exacting scrutiny. So it says that the First Amendment is very powerful. People are free to say a lot of stuff, offensive stuff, really bad stuff, but then at some point it crosses a line. And that line, as alleged in the Fulton County indictment being brought by Fani Willis, as Trump and his co-conspirators were indicted for, crosses that line. And here's what that line is. These excluded categories, when you cross the line, include speech integral to criminal conduct, fraud, or speech presenting an imminent threat that the government can prevent. Restrictions on speech integral to criminal conduct have never been thought to raise any constitutional problem. Think about that. Restrictions on speech integral to criminal conduct have never been thought to raise any constitutional problem. Because Donald Trump is arguing that his conduct, which is alleged to be criminal and trying to overthrow the results of a free and fair election, Trump and his MAGA base claim that should be protected by the First Amendment. Not so, never so, says Judge McAfee in his order. Going back to the first paragraph of the order by Judge Scott McAfee, he goes, the defendants seek to dismiss the indictment on an as-applied and facial First Amendment grounds. They argue that the prosecution violates the First Amendment protections of political speech and activity, freedom of association, and the right to petition Congress as applied to their alleged conduct, and further contend that the indicted charges are overbroad. After considering the extensive briefing, the argument of counsel, and the indictment, the court finds these vital constitutional protections do not reach the actions and statements alleged by the state, nor do the statutes themselves facially violate the First Amendment. The defendants' motions are therefore denied, a major loss for Donald Trump. Another point I want to make, because you probably saw some of the takes that we were doing about Judge Eileen Cannon giving these hypothetical jury instructions that Judge Cannon in the Southern District of Florida federal case wanted special counsel Jack Smith to engage with these hypothetical scenarios. As I was saying, that's not what judges are supposed to do. The judge gets a motion and the judge rules on a motion. You either deny the motion or you grant the motion. You don't have prosecutors engage with unlawful prosecutorial standards. And
your dog is a member of the family. Serve them top quality food they deserve. Serve them Nom Nom. Nom Nom delivers freshly made dog food personalized to your dog's preferences and unique caloric needs. Dogs love great tasting meals just like us, yet their nutritional needs are different than ours. That's why Nom Nom's nutrient-packed recipes are developed by board-certified veterinary nutritionists, freshly made and shipped free to your door. It's made with 100% premium ingredients, which means 0% freaky fillers or funky stuff. Nom Nom has already delivered over 40 million meals. That's because the best dogs, like yours, deserve the best food. Nom Nom. Whether it's Chewy.com, PetSmart stores, or delivered straight to your door, Nom Nom provides your dog's favorite recipes whenever, wherever, and however you want them. Say goodbye to boring dog food and give your dog a reason to run to their bowl with every meal, every day. By now, you know my dog Mochi is my best friend and my little baby girl. Look, I'm putting photos of me with her up right now. That's why I only feed my doggo Nom Nom, because she deserves the best. Nom-faced assured or your money back guarantee. Nom-faced is nom speak for dogs deliriously excited about dinner, by the way. Nom Nom is now available at Chewy.com and your local PetSmart stores, or for 50% off your no-risk trial box, go to trynom.com/Meidas. That's spelled trynom.com/MEIDAS for 50% off your first subscription order.
As I was critical of the way Judge Scott McAfee conducted the hearing regarding the potential disqualification of Fulton County District Attorney Fani Willis for allowing in all of this salacious and I think irrelevant matter about Fani Willis's personal life and sex life and things that do not need to be aired out in court, have nothing to do with whether there was this materiality of a conflict of interest that has so permeated the prosecution and tainted the prosecution so as to merit disqualification. But I will say that Judge McAfee, in his written orders, is very meticulous. He's had some orders that I've disagreed with, some orders that I've agreed with. That's life. That's life. And you respect a well-reasoned order, not engaging with hypotheticals like Judge Cannon does. And this is a very well-reasoned order. It goes through the various statutes, the criminal statutes under Georgia law, like OCGA section 16-10-23, which says it's a crime for an individual to falsely hold himself or herself out as a public officer or employee with the intent to mislead another into believing that he or she is actually such an officer. Or OCGA section 16-19-1 sub B, an individual commits the offense of forgery in the first degree, quote, with the intent to defraud, he or she knowingly makes, alters, or possesses any writing other than a check in a fictitious name or in such a matter that the writing as made or altered purports to have been made by authority of one who did not give such authority and utters or delivers such writing. And there also, as applied to fake elector schemes, submitting fraudulent documents to try to overturn the results of a free and fair election. Or how about this? Georgia's RICO Act, OCGA section 16-14-4, facially and as applied. Or how about OCGA sections 16-10-20, false statements and writings and false filing of documents to their conduct, which basically talks about how, individuals are submitting, fraudulent documents to overthrow the results of a free and fair election. So think about that. And Trump trying to argue that those statutes are unconstitutional as applied to the conduct because of his right to First Amendment speech. And just think about the lunacy of that, right? That's like a bank robber who shows up, who says, give me all of the money, I'm robbing the bank, doesn't actually rob the bank, runs out, gets away, is later caught, criminal charges are brought, and the bank robber goes, I was just doing First Amendment speech. That's all I was saying. I was saying, give me the money. That's all I was saying, like that. First Amendment protection. That just goes to show you how absurd and ridiculous and offensive Donald Trump's arguments are, that these crimes that are speech, that are integral to the criminal conduct, that Trump's saying, I have a First Amendment right to do it. But think about Donald Trump's, all of his defenses. I have a right to do it. I have immunity. I can say what I want. I can do what I want, whether it was before I was in office, I was after I was office. None of these laws apply to me. When, as a Presidential Records Act, you can telepathically declassify records and declare it mine, mine, mine. You can order SEAL Team 6 to kill your political adversaries. You can utter any words that you want to utter, and you can get it with it's another version of that with Trump's First Amendment arguments. But I'm glad Judge Scott McAfee has rejected it in very strong terms, and you've now know why he rejected it. It's a good ruling. I'm Ben Meiselas. This is the MeidasTouch Network. Hit subscribe. Let's get to 3 million subscribers together. Thanks for watching, folks.
Hey Midas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.